If in fact you're put in a position where you have to defend yourself with your firearm in the state of Illinois, and that firearm has an extended magazine, very likely the state's attorney's office is going to be asking that you remain in custody from the time of your arrest all the way until the time of trial. Dave McDermott here, McDermott Law Group, not your typical attorneys. Guys, why is this so significant? Because yesterday, Kimberly Fox, effective yesterday, is no longer the Cook County State's Attorney's Office. Instead, it is Eileen Burke. And Eileen Burke specifically stated, effective immediately, amongst other things, she is going to be seeking detention for the following different types of categories. One of those categories is if, in fact, you are being charged with a detainable offense and the offender, the person that's being charged, possessed or used a firearm with an extended magazine. She has made it clear that she is going to be asking that you not be released from custody, that you be held in custody from the time of your arrest all the way until the time of trial. Now, why is this so significant? Because there are a number of different detainable offenses. Some of them are very serious with respect to, like, for example, murder, attempt murder, aggravated battery with the firearm, which is on the cusp of between these felonies here and those felonies over there, but very serious offenses. But then there are some less serious offenses, such as aggravated discharge of a firearm and reckless discharge of a firearm. Aggravated discharge of a firearm, for example, is discharging your firearm in a manner that could have actually struck somebody. And reckless discharge of a firearm is discharging your firearm in a manner which is basically the equivalent of a warning shot, basically into the air or into the ground, which very often prosecutors will argue. The same prosecutors that are asking for detention will say, you know what? All this person had to do is fire off a warning shot. They could have stopped this attack. If they really believed that they were about to be attacked, they could have fired off a warning shot, which sometimes, as we know, is not practical. It's not a reasonable option. But nevertheless, that's what's being argued. So if, in fact, you discharge your firearm into the ground, for example, or into the sky to try to thwart off an attack, this is a Class 4 felony, which is typically punishable between 1 and 3 years in prison, but also carries a sentence of potential probation instead. And now, on a charge that you could receive probation for, just because you have an extended magazine in that firearm, they're going to be arguing, they're going to be asking the court to deny you release and to keep you in custody until the time of your trial. What do you think about this?